In a Texas divorce case, the court is going to have to distribute and allocate all of your assets and liabilities from within the marriage. So the way that happens is you and your lawyer will figure out, okay, what are all the assets that have been created during this marriage? And what are of the debts that have been created during this marriage, and then bring that either to mediation or to your Texas divorce court and have them allocated by the court or by agreement. In Texas, there's a law governing divorces that deals with how the assets will be distributed, and that's community property. Now, Texas is a minority jurisdiction, and that just means we do things a little different, but that's no surprise to you that we do things a little different in Texas. And community property, what that means is everything earned essentially as the result of your efforts during the marriage is the community's. That means it's both of y'all. I think of it like you're creating a bucket. And whenever you go to work and you get money from your job, or they go to work, they have their small business and make income, all of those resources are poured into the community property bucket, and then the court has to distribute those at your final trial at the end of your divorce, or you and the opposing party have to agree with how to distribute what was put into the community property bucket at mediation. To understand how Texas distributes assets in a Texas divorce case, you need to understand both community property and separate property concepts. Now remember, community property is the presumption of all the stuff y'all own during your marriage in Texas. But here's the thing, not everything is necessarily community property. You could prove by clear and convincing evidence that certain things should be labeled as your separate property. And things that were owned prior to marriage or your interest in it vested prior to marriage could be considered separate property by the court. Also, gifts or inheritance that you received during the marriage, if handled properly, also could be considered separate property. So stuff you owned prior to marriage, assets, things like that, property, money, bank accounts, real estate, and those things you received during the marriage by gift or inheritance may be considered separate property in your Texas divorce case. The length of your marriage really doesn't affect property division in Texas. Now, it could affect things like spousal maintenance, but the amount of time really doesn't affect the way the laws work, except that the longer you've been married, the more likely you've accumulated more community property. So that's more of a function of time than a function of the law. Your retirement accounts are treated just like any other asset during the marriage when it comes time to split everything up in your Texas divorce case. So what that means is each asset has to be considered, including retirement accounts, of when you had the right to that thing. When did your interest in the retirement account vest? And if it was entirely during the marriage, then it's likely that asset is community property. If it was vested or you had it prior to marriage, that may be your separate property. And if both things are true, then you could have a mixed character asset that has to be traced and proven which was separate and which was community. It gets a little complicated at that point. But the retirement assets like your 401k or IRAs are subject to the same community and separate property laws as other normal assets. In Austin, Texas, we have a lot of business owners. So one question that comes up quite frequently is how a court will handle your small business or your medium or even your big business. If you have an LLC or a corporation, you may be wondering, how is this going to get handled in my Texas divorce case? And we go back to the basics. The law about community and separate property will apply to how your Texas business will be divided in divorce. If you created this business during the marriage, it's going to be presumed to be community property and subject to a just and right division of your estate. Now, if you formed the business prior to your marriage, it may be you could prove that business is a separate property asset. It depends on when the thing was formed, number one, and then number two, did you respect the corporate form? So what sometimes people do is they will commingle their assets of, say they have a business prior to marriage, and then during the marriage, they move money in and out. They run the credit card of the business for a trip to HEB down the road in Austin. If that happens, you could complicate matters. But essentially, a Texas court will apply the community and separate property legal scheme to your Texas-based business. If you can show fault in the breakup of the marriage or misconduct during the marriage, you may be entitled to a disproportionate share in the division of the estate. Essentially, what you're asking the court to do is punish the other party for some sort of a bad act or some sort of secret keeping. And you'll say, hey, judge, this person did this wrong thing. Like, let's say you're pleading for fault on the basis of infidelity in your Texas-based divorce. You might say, judge, because they were unfaithful to the marriage, I should get more assets and more money and less of the liabilities in the final distribution of assets in my Texas divorce decree. So yes, you may get more money, but it's definitely not guaranteed. You'll need to talk to a Texas-based divorce lawyer like us in Austin, Texas, to see how the court might treat fault in the breakup of your marriage.